So 8.5 it's the last section of contracts here, which is always a good thing because, like I said earlier, contracts is such a big topic in the class. But 8.5 deals with what I call the unusual or exotic purchase contract, the ones that simply are not commonly used. So obviously this would not apply to like the 2T NC Realtors contract because that one is very commonly used. These that are in this section, there is no pre-printed fill in the blank version of them. Whenever you have buyers or sellers that find themselves in a situation where they feel like they need one of these contracts in this section, immediately your advice should be to them, let's go to an attorney. Let's go talk to a real estate attorney. Let's get you some good advice, some good representation here, because what you're about to wade into is far beyond my ability to provide you with services. Let me be clear. There is no such thing as a fill in the blank, anything that we're about to talk about in this section. Is everybody with me on that? Okay. Mm-hmm. These are very specialized agreements, especially the first one that we're going to talk about, the installment land contract. The installment land contract is a contract in which, and they come in so many names. Let's clear that up first. It can be called land contracts. They can be called installment land contracts. They can be called contracts for deed. They can be called rent to own, even by some people, even though that's not really a formal name for them. So first thing to know about the installment land contract when you're studying for it on a test, and you will see test questions about it because it's such an odd one, is to make sure you understand how many names it has. There are quite a few names that go along with this thing. So what's happening in this installment land contract? In most transactions, the seller is getting all of the money at closing. They're getting the full purchase price. Either the buyer's paying cash, in which they pay all the cash at closing. Seth just sent me a message and said he could hear me tapping. No, what you hear is Zelda scratching the rug over here. She
oh my God,
trying to fluff the rug up.
It's distracting me.
Sorry. I'm sorry about
It's
that.
all right.
See if I can get her to stop.
It's okay.
It's her, not me this time. But the seller in most transactions gets all of their money at closing, and that's not going to happen in this transaction. Whether the buyer in most closings pays cash or gets a loan, the old expression is it's all cash to the seller. Because if the buyer gets a loan, isn't that going to be the equivalent of cash to the seller when we get to closing? Yeah. They're going to get all their money, but not in an installment land contract. In an installment land contract, we are actually combining the sale and the financing into one overall agreement. The buyer is not, to be clear, not borrowing money at all. There is no loan here. This is not seller financing. Let me say that again. There is no loan taking place here. Is everybody with me on that? The buyer is simply making payments and paying installments to the seller. They are paying off the property in installments to the seller. There is no lender at all. So there's not going to be a note involved. Is everybody good with me on the fact that there's not a note? Now, here's why this is so different than any other sales transaction. Look at this statement. Since the seller is not being paid in full at closing, the seller is going to keep legal title of the property until every installment has been paid. Think about a normal transaction, folks. When is legal title transferred over to the buyer? As soon as closing happens, right?
Yes.
And then the buyer might sign a deed of trust, or they might sign a mortgage giving collateral in the property to a lender, but then that lender would have to go through the foreclosure process if the borrower defaults on the note. Everybody good with me on that?
Mm-hmm.
In this case, folks, nothing is changing hands about ownership at all. The buyer is simply starting a payment plan. Now, the only difference here is between this and maybe like layaway is in layaway, you don't get to use the stuff until you fully paid for it. But in this version of layaway, the buyer is going to begin to use the property and enjoy the property right away. But who still owns the property? This is the big connection.
Seller.
This is the seller's property. The seller is not going to sign a deed. They are not going to transfer a title until the very last payment has been made to them, which could be 10, 15, 20 years down the road, that the seller is going to hold on to this. And Elizabeth, you're exactly right. The buyer is going to get equitable title in the property, which just means use and enjoyment. But legal title is going to stay with the seller in this case. And here's the interesting thing about this. The buyer is going to also take over all the responsibilities of ownership. Guess who has to maintain the property now?
Buyer.
The buyer. Guess who pays property taxes?
The buyer.
The buyer. Guess who has to buy insurance?
Buyer.
The buyer. But guess who has legal ownership of the property?
Seller.
The seller does. The seller does. And usually sellers are charging pretty high interest rates to do this. So this should really be a last resort for buyers. So which ones do it? Well, the ones who do it are the ones who can't do anything else. Some buyers, just for whatever reason, are not able to obtain traditional financing. Maybe they have poor credit. Maybe they have no credit. Maybe they have income that they cannot document. I mean, let's just get real with each other, folks. Are there people out there who have substantial cash flows coming into their household on a monthly basis who, for whatever reason, no judgment, whatever it is, I don't know, don't care, don't want to know, cannot document said income?
Yes.
Yeah.
I mean, I'll never forget, Leslie came to me one time years ago and she said, well, I have a problem. And I said, why? And she had a gentleman who was her client, and she always referred to him as her produce guy. That was the way she always referred to him, was her produce guy. And she said, well, you know, my produce guy is buying this house down in Garner. And I said, yeah, what's the problem? She said, well, the problem is he's got the money in cash. And I said, what money in cash? And she said, the purchase price. And I said, well, he can just do a wire transfer. She said, no, you misunderstand. When I say he has it in cash, I don't mean he has it in funds available in a bank. He has it in cash. And I said, what's the purchase price? And she says, $180,000. I said, he has $180,000 in bills, in actual cash? And she said, yeah. I said, what kind of produce does he sell? Don't answer that question. I don't want to know.
Crumpled singles, right?
What produce business he's in. I can guess on my own. I don't need to know any further. Okay?
Oh, isn't that funny?
I said, but that's a problem, you know, because we got to be able, but y'all see what I mean? Are there going to be buyers who have income but cannot necessarily document this income and who may need to do some interesting things to make these transactions happen? Does that make sense for people?
And it can be good for a seller, Travis, because when interest rates are as low as they are now, people who are on retirement income, they don't need their whole purchase price up front. They can take it monthly with interest and probably make more.
That's right. If you were selling a home and moving to a nursing facility right now, wouldn't an installment contract be a pretty good idea for that kind of a seller?
Yeah.
I mean, if you could take an installment contract and sell your house to somebody and they pay you an 8% interest rate, well, that's better than what you're going to get on your money. And all you need is the money to live off of monthly anyway. You'd probably be better doing an installment contract as a seller. Sometimes sellers need these because they have properties that they're having trouble people getting financing on. So an example of this, I dealt with a seller several years ago, and they had a property they had inherited from their parents who were deceased, and the property was in terrible shape. And it was in such shape that there was no way an appraiser was ever going to let it fly if somebody was borrowing money. And it was in a part of the state where you just couldn't find cash buyers. I mean, people just didn't have cash. People needed to borrow money, but you couldn't get a lender, and the seller didn't have the money to fix the property up himself. He's like, well, I don't know what to do with it. He's like, do I burn it down? Like, I can't sell it. I can't fix it up. I don't have the money. I said, well, we could consider an installment contract. If you can find a buyer, they can make you monthly payments on it. Does that make sense for everybody? Why you might do that in that sort of a situation, right? So they do have their use for them, but there are tremendous dangers for the buyer. The buyer is taking a huge risk when they do an installment contract. They can't refinance because they don't own the property. They can't borrow money against a property they don't own. They can't sell it because they don't what?
Own it.
They don't own it. They can't, in some cases, pay it off early. Some of them are written to not allow an early payoff, depending on how the thing is structured. And then the big one, look at this statement right here, folks. There's the whopper right there. A buyer who's doing an installment land contract would lose everything they had paid if the seller reclaims the property because of a missed payment. So let's say we have a buyer doing an installment contract for 20 years. And for 18 and a half years, they have made every single payment on time. Could they, in theory, depending on how this thing's written up, could they miss one payment in year 19 and lose every dollar that they've paid into that property?
Accorded with that one, yeah.
They can.
And you wouldn't have to go through foreclosure if you were the
There
seller.
is no foreclosure because the
I know.
buyer never took ownership of the property. The
They don't-
seller will literally just say, get out.
What if the seller takes out a mortgage on the home?
Well, the seller hopefully would not be able to take out a mortgage on a home. It's a great question because, and there's a reason for this now, installment, I'm going to make a statement here. Installment land contracts need to be recorded.
Okay.
Why do you think that is? To tell anybody and everybody far and wide, number one, this seller should not be selling you this property because they're already in the process of doing what?
Selling it.
Selling it to somebody else over a long period of time. Number two, you should not lend this person money with this property as collateral because they're in the process of doing what?
Buying it.
Of selling it to somebody else. Somebody else is making them payments on it. So Sierra, does that make sense then why we would want to record these installment land contracts so that
Yes.
the seller couldn't do that?
Definitely.
Okay.
Travis,
Yes.
going back to the produce guy, if he wanted to
I don't
pay,
have his phone number, Taj, so I don't know about it.
no. But if he wanted to pay the $180,000 to the seller using this methodology for installment contract, can he just pay everything up front? Does he really have to put everything in installments?
Well, that just depends on how every installment land contract is written up per agreement. You'd have to have an attorney write it up. And so it would be the terms they wanted to come to. If they wanted to write it up to say that he could pay it off early and he just wanted to pay, $10,000 a month and pay it off real fast, he could do that. That's completely between the buyer and the seller because these are not standardized agreements, but they're not regulated because they are completely private agreements.
Awesome. Thank you.
Yep. Okay. These buyers cannot cash out any equity because they don't have any equity. Remember, equity is what you would get if you sold at any given time. Well, they can't sell because they don't own. So basically, they have to make all these payments. And there's obvious disadvantages for the seller too here. It takes a long time for them to get their money. If another better qualified buyer comes along, they can't sell to them because they've already promised the property to somebody else. Just remember some, vocabulary words important to remember. Whenever we have this contract for deed or installment land contract, it means the same thing. The buyer has equitable title to the property while they're making payments. They don't get legal title until they've made every payment. Are we all clear on that?
Yes.
Yes.
And that buyer does not have the same rights as they would if they had purchased the property and used a more traditional deed of trust or mortgage, where they would have to go through the foreclosure process. They're much less protected than they would be if they financed it with a more traditional financing method. These do need to be recorded at the county courthouse where the property is located. To Sierra's question earlier, this is what prevents the seller from selling to another buyer while the agreement's ongoing, or from borrowing money against the property while the agreement is ongoing, because that would be a disaster. You know, if the seller was able to go out and essentially encumber this property with a bunch of debt, they could lose it to foreclosure, and the poor buyer has been making all these payments and gets screwed over. So that we want to record these things. This is why an attorney would need to get involved early with this, because the first thing the attorney would want to make sure, does this seller own this property free and clear? Because if this seller has any encumbrances whatsoever, any liens, you don't want to do an installment land contract. So we would want to make sure that the seller didn't have any debt, didn't have anything. And then we would want to make sure to write up a really good installment land contract and have it be recorded so that the buyer's interests are protected. Very, very unique type of purchase agreement. Now, that is often confused with something called seller financing, and they are not the same. They look the same in some regards, but they're not the same in impact or effect. We've talked about seller financing briefly before, but I'm going to talk about it again here now. If the seller agrees to loan money, now we're talking about a loan. Are we going to have a promissory note?
Yes.
Yes. If the seller agrees to loan money to the buyer with a promissory note, then the buyer now has the money to pay for the property. I know it's hard to wrap your brain around this sometimes because you want it to be so absolute. No, they don't. They just got me. Isn't a loan from the buyer's perspective?
Yeah.
Yes.
It doesn't matter who they get the loan from. They get the loan from a bank, they got the money to buy the house. They get the loan from Patty, they got the money to buy the house. They get the loan from the seller, they got the money to buy the house. Does that make sense for everybody? So this is a transaction where they borrowed the money from the seller. So now they have the money to purchase the property. Are they going to use that money to purchase the property?
Yes.
Yes, which means they have paid in full for the property, which means title is going to be transferred right away. Do you see the big difference all of a sudden now here between the installment land contract and seller financing?
Mm-hmm.
Seller financing, the buyer gets legal title to the property right away. And they're still going to be making payments back to the seller, but they're making payments on that note. Which means if they default on that note, yes, the seller could end up taking the property, but they would have to go through what legal process to get there?
Foreclosure.
That's right. Would have to go through the foreclosure process to get there. Which one do you think is better for the buyer's interest if you're comparing the installment land contract versus seller financing? Which one is better from the buyer's perspective?
Seller
Seller financing, which means which one is better from the seller's perspective?
Installment.
Installment contract. That's exactly right. That's exactly right. I mean, they both end up with the same sort of impact. Buyers making payments to the seller, but there's a big difference between buyer making payments to the seller on a note versus and owning the property versus buyer making payments to the seller and not owning the property. Big difference there.
So the buyer can actually sell this property.
Yes, the buyer can do, that's a great question, Lou. The buyer can do anything they would normally do with any other transaction involving a loan. They can refinance it, they can sell it, they can go out and take out a home equity line against it. They can do anything that they would normally do because they own this property. That's exactly right. Okay, everybody good with that? Okay, so make sure you know that seller financing is different than the installment land contract. Now, the option to purchase. The option to purchase is a contract that allows buyers to essentially lock down the property while still having the right to change their mind. We're going to lock the seller into pricing. We're going to lock the seller into a closing date. But the buyer has the right to change their mind for a certain period of time. You know, it's really weird. I sort of feel like, God, I just feel like we've talked about something that seems similar like this already today. Is it just like deja vu for me, or is it, do y'all realize that, have we talked about something where the buyer is not locked in for a period of time, but the seller is locked in for a period of time? Have we talked about something like that?
Due diligence period.
Due diligence.
How about the two? So would it be fair to say that the 2T contract from NC Realtors is an example of an option contract? Would that be a
Yeah.
fair statement?
Mhm.
Yeah,
That's exactly what it is. That contract is an example of an option contract because the seller is locked in to those price, those terms, but the buyer is not locked in. Now, here's why we teach it to you twice. On the North Carolina section of the test, they're going to talk to you about the 2T offer to purchase and contract. What are they going to call this type of agreement on the national section of the test?
Option to purchase.
They're just going to call it an option or an option to purchase, but they are the same thing. Does that make sense for everybody?
Mhm.
2T is just an example of an option to purchase. So now let's ask the next question that might show up on a test. Is an option to purchase an example of a bilateral or a unilateral contract?
Unilateral.
Unilateral, because the seller is locked in, but the buyer is not during the option period, right? Does that make sense for everybody?
Mhm.
Okay, it's a unilateral contract. And instead of a due diligence fee, what would they probably call it on the national section of the test?
Option fee.
An option fee. Well, see, I told you earlier, we're the weird ones out. And I'm like, nobody else does this. So why would this be on the national section? Let me tell you where this is actually used in all 50 states. Just we're the only ones who use it in residential real estate. Guess where this type of purchase agreement is normally used, folks?
Commercial.
Commercial real estate. This is by far the most common example of a purchase agreement in commercial transactions. Because if you think about it, with a commercial transaction, buyers very often need to do a lot of investigation to see if that property is going to work for them. They might need to do environmental studies. They might need to do traffic studies. They might need to talk to the zoning board. Well, in the meantime, they don't want the owner to sell the property to somebody else. So instead of coming to a full purchase agreement, they will take out a what on the property?
Option to purchase.
Option to purchase the property. They will pay the owner some amount of money to lock the property down at a certain price for a certain period of time while they can do their homework. Does that make sense for everybody? We're just the only-
Travis,
yes.
Travis, a lease option to buy, is that an installment contract or is that an option to purchase?
So there really is no such thing as a lease option, but if you were going to label it as one, it would be an installment land contract. A lease option is most likely a installment land contract in North Carolina. We don't technically have anything called a lease option here. But and somebody sent me a private question, would there be a lien recorded in seller financing? Absolutely. I mean, it's a lien. Seller financing is a lien just like any other lien on the property. The seller is just functioning as a bank. Right. And they wouldn't have the right to foreclose if they didn't have a lien. So when you talk about options on the national section of the exam, just think of the 2T contract. The option period is the same thing as the due diligence period. The option fee is the same thing as the due diligence fee. Does that make sense for everybody?
Mhm.
It's
So
a-
even though the 2T contract, Travis, is a option to purchase agreement, it's a very specific type of option to purchase agreement.
That's correct.
And it's very important not to confuse, like noted in unit either, I think it's 8.3, the specifics of the 2T contract and use it for the national generalized option to
That's
purchase.
exactly right. If you're on the national section of the exam, don't use any of the information about the 2T contract because the 2T contract's only used in North Carolina. And on the national section of the exam, they would ask you very generic things about option contracts. Is it bilateral or unilateral? Well, we know it's unilateral. What is the option holder? What are they doing? What are they promising? Well, the option holder, which is the buyer, is not promising anything. They're promising just to think about it. What is the seller optionor doing? Well, they're promising to hold the property and not sell it to somebody else. Could this be painful for a seller who gets an offer from somebody at a much higher number to know that they already have given an option to another buyer at a lower price?
Yep.
Yeah. And you will see. So I'll give you an example of who does this all the time. Give you an example of who does this all the time. Do you think if somebody knew for sure that a Walmart was going to be located on their property value, they'd want to charge more for it? If they knew for sure that Walmart had decided this is 100% where we're going to put our store, that the price would get jacked up on that property. What do y'all think?
Mhm.
Yes.
Yes.
So let me tell you what Walmart will do. They will send somebody into that town and as a buyer for Blue Ribbon Properties LLC, something that sounds nothing like Walmart, some unaffiliated LLC or corporation. And the buyer for Blue Ribbon Properties LLC will say, okay, these 3 sites are our best choices. Is everybody with me so far? But we need to do further research here. Is that research going to sort of give away who they are? When they start contacting the planning and zoning office, are they going to pretty much have to tell them we're Walmart and we're trying to figure out if we can put a store at this location? And is that going to get back to the property owners and jack the price up?
Absolutely.
Yes, unless they go to the property owners before they ever start doing the research and take out a what on each one of those properties?
An option.
An option. They'll go to each one of those property owners, they'll negotiate a price, and the property owner said, well, what are you planning to do with the property? I don't know. We got no idea, really. We just thought it looked like a nice property. So, but here's the thing, we don't even know if we really want it. So we'll pay you $10,000 just to think about it for the next 6 months, and then you promise to sell us the property for $250,000 if we decide we want to buy it. And if you got sellers that have been sitting on property for a long time, are they likely to agree to that in a lot of cases, especially if they don't have much interest?
Mhm.
Right? So they take their $10,000. Meanwhile, as soon as they get all 3 options in place, Walmart's going to do a damn press release that says they're coming to Lillington, North Carolina. And it's going to be at one of these 3 locations. And they will right out in the open start negotiating with the planning and zoning office, the Department of Transportation about putting an extra on-ramp, or extra lane, a stoplight, all this stuff. And they will figure out which of those 3 locations is going to work the best for them. And then they will exercise their option and purchase that one once they figure out which one of those 3 works the best. Does that make sense? And you know who's going to want to vomit? The person who's selling to Walmart for $250,000 because they sold an option at that price before they knew it was Walmart. That's the use of an option contract. That makes sense for everybody?
Yep.
Okay. Okay, good. And like I said, the choice here is going to be simply buy or don't buy during the option period for the buyer. Once you're under contract, obviously the buyer has an advantage because they control what happens. And this is unilateral. The last type of agreement in this little section that we talk about is something called the right of first refusal or right of first opportunity. Whenever we have a right of first refusal or right of first opportunity, we don't actually have a sales contract. This is the loosest type of agreement in real estate because neither party has promised either to buy the property or sell the property. I want to be clear, this is the only, so in a bilateral sales contract, how many promises of buying and selling do you have in a bilateral sales contract?
Two.
Two.
In a unilateral sales contract, like an option, how many promises to buy or sell do you have?
One.
One, right? Well, a right of first refusal is a real estate contract that has no promises to buy or sell at all. The seller hasn't promised to sell. The buyer hasn't promised to buy. So it sounds like a grand waste of time, but there's one important factor here that is promised. The seller is promising this buyer the first shot if the property is ever sold in the future. In other words, it becomes the seller's responsibility when and if they want to sell the property to track this buyer down and give them the first what?
Trying opportunity.
First opportunity to purchase the property. Everybody with me on that? Is the first opportunity. Generally, the way that plays out is the buyer that has the right of first refusal is going to get the opportunity to match or beat any other offer on the property. So as an example, this happens a lot with people who are leasing property long-term. Like you'll see this, if you've got a restaurant that's operating in a building, the restaurant's been there for 30 years and they're renting the building they're in their lease, they might have a right of first opportunity to purchase. In other words, if the landlord wants to sell, they have to give them first shot at what?
Trying to
Gives,
pay.
sell, buy.
At buying it. They have to give that current tenant first shot at buying it. You might also see these where somebody has given a neighbor the first opportunity to purchase next door property, for example. Or it simply means when and if this owner gets ready to sell, they have to go to that person. These are recorded because otherwise, how would we know they exist? But they're not a tremendously big deal. So I'll give you an example of what we had. I listed a property, it's probably been 6-7 years ago now, down in Clayton. And when I was doing my little research on the property before we listed it, I found a right of first refusal that had been recorded. And the guy who owned the property had inherited it from his grandfather, but the grandfather gave a right of first refusal to his cousin on the property. Before the grandfather died, when he was alive, he gave his cousin a right of first opportunity to purchase the property. Now the grandfather was dead and the grandson had inherited the property and wanted to sell it. And I simply said to the current owner, the grandson, I said, we have to find your cousin, whatever he is. We have to find him. He said, why? I said, because you have to give him the first what?
Right of refusal.
The first opportunity. And so we finally found it. He was in Florida, retired. And we had our attorney send him a letter saying, do you want to purchase this property? Here's the anticipated list price. Are you interested in making a full price offer on the property? And if so, let us know. And the guy sent us back a note that said, I have no interest whatsoever in purchasing the property. All we did was kept that on file. So whenever somebody brought us an offer and said, hey, I see you have this right of first refusal, we could provide them. Yep, we've already talked to them. They're not interested. Moving along.
Would this be uncommon for a buyer to present this to a seller? Like
What do you
wanting
mean?
the first
What do you mean?
option to purchase?
I gotta know where your brain is. Would this be
Okay.
for a buyer to present? this
Okay,
to
so
a
like a family home that someone grew up in that ended up in the market, it sold. If they were wanting to, potentially purchase it in the future.
Okay, so that wouldn't be a buyer presenting this to a seller. That would be the seller tacking this on to the property when they sold it to somebody else. And I'll sell you the property, but you have to give my grandchildren the right of first refusal if you ever sell it.
Okay.
Is that what you're trying to ask?
Something like that.
Well, then what are you trying to ask? You gotta
Okay.
help me out.
So I was curious for a personal reason. So my father, he was living in this home and he actually passed in the home, and my brother is wanting to purchase the home, like, would this be a situation where he could contact the owner of the home? Are you tracking me?
Yeah, yeah, he can contact the
So-
owner if he wants to buy the home. Are you saying the owner doesn't want to sell? Here's my point, Sierra. You don't need a right of first refusal if the owner wants to sell. Just go ahead and do what?
Well, he
Buy it.
has told my brother that he can purchase the home, but with something like this, it would need to be documented. Would this be the right?
No. If he wants to
Okay.
purchase the home, just move ahead. Here's what a right of first refusal is for. The current owner doesn't want to sell, but you're trying to lock it down. So if they ever do in the future, they have to come back to you. This would be used if your brother had contacted the current owner and the current owner said, listen, I got no interest in selling, but if I ever do, I'll come back to you first.
That's what
where
he
you-
said. That's what he
that's where you-
said. Yeah, he said, I'm not interested in selling at the moment, but when I am ready to sell, I will contact you.
Then yes, that would be a right of first refusal, and that needs to be written up by an attorney and recorded to be enforceable. Otherwise, it's not useful.
Okay, okay,
Yes, that's exactly
thank
right.
you.
That's exactly what a right of first refusal is. If you ever decide to sell, you have to come see me first.
Gotcha, thank you.
You're welcome. And that is it for Unit 8, folks. That's all.
Wrap.
Oh, Travis, one quick question. When your people had that first right of refusal,
Mhm.
when you found it on title, did you then record, is there a document to record to take it off?
Yes, we had the attorney draft up a document and send to the person that had the right of first refusal, saying that they had been offered the right and they had refused. And so that terminated the right of first refusal.
Well, how do you get it off the title?
So when they signed that document and sent it back, we took it to the courthouse and
Okay.
recorded it.
You have to record it then?
Take that document and record it, and that
Okay.
cancels out the first one.
That's what I was getting at. Okay, thanks.
It's just basically just like a satisfaction of mortgage. You know, how do you cancel the mortgage? Well, you file a satisfaction of mortgage, you know.
Yeah, got it.
Okay. All right.